Hello everyone, welcome to Legal Darshan. In this video, we are going to discuss the case of Government of NCT of Delhi and another versus BSK Realtors LLP and another. Now, this is title numbered at 81 in the list of AOR leading cases. And in this case, we are going to expound upon two issues. One is res judicata, that whether res judicata would apply when the matter has been already decided by the court and in the first round of litigation, and whether it res judicata will apply against other appellant in the second round of litigation by against other appellants in this case. Okay. Now, one thing that we are going to discuss is about res judicata, and another thing that we will discuss is about doctrine of merger. Okay. Now, this merger is not the merger that we discuss in the merger and acquisition subject, but rather this merger is defined as something else. Okay. Now, what is this doctrine of merger with respect to this case? What we are going to do is we will first discuss what doctrine of merger is, and next we will discuss the contested question in this case, which is contested provision in this case, which is section 24 of the Land Acquisition Act of 2013. Okay. Now, one thing that is needed to be known here is the Land Acquisition Act of 2013. It is replacing the earlier Land Acquisition Act of 1894. Okay. So now here in the main question is the new act is titled as, the name of the new act is Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation and Resettlement Act of 2013. Okay, now we are basically revolving the discussion around section 24 of the new act of Land Acquisition Act of 2013, and we will come to what section 24 is. But before that, because doctrine of merger is in question in this case, we will just have a little glance of what doctrine of merger basically is. Okay, so doctrine of merger is that once an appeal is decided by a higher court, the lower court's judgment ceases to exist in the eyes of law, and it is deemed that that they have merged with the appellate court's decision. Okay, now this is basically to ensure that there is finality in the judgment and that there are no multiple rounds of litigation. Okay, so once if a decision is established by a lower court, for example, in this case, once when decision is given by a higher court and the appeal lies in the Supreme Court. So once the Supreme Court decides this case, okay, the decision that is given by the High Court merges into what has been said by the Supreme Court, and then it will have no validity in the eye of law because the appellate court takes the position of being the court giving final order, the order that will be taken as binding and in finality. Okay, so that is the doctrine of merger. Okay, now the question this case is being now the question before the judges, it's a 3-judge bench decision: Justice Suryakant, Justice Dipankar Datta, and Justice Ujjal Bhuyan, and the main issue is revolving around res judicata, and second, that whether the doctrine of merger will operate as a bar to entertain civil appeals in the present case. That is also what this case is exploring. Okay, so now we know that what is the main contention, what is the bone of contention of this case, and before proceeding to that, we will need to understand what section 24 clause 2 is. Okay, so a brief summary of section 24 that is under the interpretation in this case is basically it was required by the 2013 act that any act of acquisition, any land acquisition proceedings that was initiated under the previous act, which is repealed, the Land Acquisition Act of 1894, the provision is saying that they will deem to be lapsed if the physical possession of land has not been taken or the compensation has not been paid for the said land acquisition proceedings. Okay, so now we are interpreting this particular section 24 clause 2 in this case. Okay, now basically what happens in this case. Okay, we'll just come to what a brief facts of the case. Now what is happening herein? All right, so basically there are multiple litigations that are happening. Number one, in this case, now this case basically the flow of proceedings goes like, so Delhi government initiated land acquisition proceedings under the Land Acquisition Act of 1894. Okay, it targeted properties owned by the respondent, who is BSK Realtors LLP, and some other property builders and contractors for public infrastructure projects. Okay, now in 2016, the Delhi High Court rules that these acquisitions projects, they have been lapsed, referring to the Supreme Court's decision given in the Pune Municipal Corporation versus Harakchand Solanki's case. Okay, which the case basically, now that case, Pune Municipal Corporation, it is basically interpreting section 24 clause 2 of the 2013 act to say that there is an or condition. Okay, now we need to understand what is happening, because there are two cases that are being taken in reference here. One is Pune Municipal Corporation, which is saying that in section 24 clause 2, to lapse a land acquisition proceeding, the condition is an or condition. Okay, so what is happening, that either your acquisition has either the physical possession has not been taken by the government under 1894 Act, which has been repealed, either in that case, or if the compensation remains unpaid. It's an or condition. Either your compensation is unpaid or possession is not taken. Any of the condition exists, the possession, the acquisition proceedings will lapse. Either if either of the condition is fulfilled. Okay. Now what happens is that DDA, the Delhi High Court, gives the decision in 2016 cases, following the lead, following what is held in the case of Pune Municipal Corporation versus Harakchand Misrimal Solanki. Okay, now what happens is that DDA goes and files an appeal against DDA and another authorities. They go and file appeal against this decision in the Supreme Court. Okay, now Supreme Court is also dismissing this batch of petition. Okay, Supreme Court dismisses this batch of petition, and in 2020, what happens? A constitutional bench in Supreme Court, a constitution bench in Supreme Court, in the case of Indore Development Authority versus Manoharlal, overrules the previous judgment given in the case of Pune Municipal Corporation, and it says, okay, now in your Pune Municipal Corporation, the condition is an or condition, that either there is no possession taken, or no compensation paid. No compensation. Okay, but what happens in Indore case? Okay, now the second case, which is a 2020 litigation. Now, what is happening in this case of Indore Development Authority versus Manoharlal? Okay, so what happens that this or condition gets overruled by and condition. The court in Manoharlal case, Indore Development Authority versus Manoharlal case, says in 2020. Okay, Indore Development Authority case 2020. This is your 2016 Pune Municipal Corporation case. Now, Indore Development Authority overrules what is held in Pune Municipal Corporation case and says that it is not an or condition, but it is an and condition, that both the conditions should be met. Like possession has not been taken by the government, as well as the consideration has not been paid, compensation has not been paid. In that condition, there will be a lapse in the land acquisition proceedings as initiated under the Act of 1894. Okay, so this is what the trajectory of events is going in this particular case. Okay, now what happens that based on 2020 decision, Delhi government goes and files an SLP before the Supreme Court of India, seeking reconsideration of 2016 High Court judgments. Okay, because the 2016 precedents now gets overruled in 2020, and therefore Delhi government goes by way of the authorities like DDA, etc., and files a petition in the Supreme Court of India, challenging, requesting, or are requesting or seeking reconsideration of the 2016 High Court judgment, appeal against which was also dismissed by the Supreme Court in 2016 as well. Okay, now the question that arises here is that whether the 2016 Supreme Court dismissal bars the Delhi government's DDA's new petition, and second question is whether the High Court's decision merged with the Supreme Court's dismissal for preventing further litigation. Okay, now because there was a Supreme Court who was sitting in the appellate forum and deciding the dismissal of the cases, so whether there is a merger, doctrine of merger applies there, and the petitioners are barred from applying for a new litigation. That is also one of the questions that we are expounding over in this case. Then also when there is a talk of meeting the ends of justice, Article 142 automatically gets invoked there. So this case is also seeking, the clarity, and this case is also expounding over the clarity on Article 142 powers vested in the Supreme Court of India. So now in this case, Supreme Court observes that doctrine of res judicata does not apply strictly in this case. Okay, court emphasized that the earlier precedent, okay, which is the Pune Municipal Corporation precedent, it is basically an overruled precedent now. Okay, so the precedent gets overruled in 2020, and wherever. Okay, now acquisition is not just a matter between the government and a person, or it does not involve just few people. Rather, it involves a lot of people. A broader public interest is involved. Okay, so court is holding that res judicata will not apply strictly in this case because there is now an overruling precedent, and where there is public interest involved, there is broader public interest involved, we do need to have a flexible approach to undertake. Okay, now court is also building upon that another question which relates to the doctrine of merger in this case. Now court is saying that, court is basically saying that when we Yes, court is answering that whether the doctrine of merger operates as a bar to entertain the civil appeals in the instant case, because earlier appeals were also dismissed by the Supreme Court. So can we apply doctrine of merger because there was a final order already existing? Now court is also relying on the public interest test, and court is saying that concept of public interest need not be viewed narrowly. Basically, the court herein is saying that doctrine of merger, we cannot apply it as a checkbox formula, or we cannot apply it mechanically, because there is Article 142 available in the Constitution of India, which recognizes that one kind of power exists in the Supreme Court, inherent power exists in the Supreme Court, which serves as an exception to the doctrine, allowing it to revisit and rectify past decisions to prevent injustice. Okay, now when we looked at the cases like Rupa Hurra versus Ashok Hurra, also when we looked at A.R. Antule's case, we actually, had a conclusion that when court is doing an error, because to err is to human, that's what I have usually said when we are discussing this Article 142 jurisdiction. And even the judges, even though they are brilliant, they are the brilliant legal minds, they are also sometimes in a position where they can also make errors. Okay, now court herein is saying that Article 142 serves as an exception to the doctrine of merger, also allowing Supreme Court, also the final court, also to revisit and rectify the past decision, so that injustice to a broader public interest can be cured. Okay, now court is reaffirming that Article 142 grants Supreme Court the authority to pass orders necessary for the ends of complete justice, and that jurisdiction, that power, that authority given to the Supreme Court of India can override procedural doctrines like doctrine of merger and doctrine of res judicata in exceptional circumstances. Okay, now this power cannot be invoked casually or cannot be invoked in day-to-day routine matters. Okay, so Supreme Court allowed most of the appeals filed by Delhi government in this case, overruling the previous decisions given to it, where there was a lapse of the acquisition proceedings initiated under the 1894 Act. Now this judgment is important because it underscores the constitutional commitment to ensure that procedural technicalities do not hinder substantive justice, especially in matters involving broader public interest. Okay, so this is one principle of law that is established here, that procedural technicalities shall not override, shall not hinder the substantive justice, because the whole objective of the law is to substantiate justice and not getting it, not letting it fall away just because on the grounds of procedural technicalities. Now, this is it which was held in the case of BSK Realtors, and Article 142 is in greater discussion here. And I hope you like this video. If you want to have discussion on more such videos, please feel free to write in the comment box below. I hope the discussion is useful. Thank you everyone for watching. Please stay tuned with Legal Darshan. Have a nice day.